Good afternoon, everybody. Thank you all for joining us for our quarterly learning session. I'm thrilled to announce that our speaker today is our own Heather Meza. She is Crawford Group's Director of Marketing Services. Heather joined us back in April and has been focused on supporting marketing outreach programs for Crawford Group. She's an expert in demand generation, digital marketing, content marketing, and MarCom. With that, I'll turn it over to Heather.
Thanks so much, Jen. Really excited to be here today. It's nothing I like doing more than helping educate marketers. So with that, I'm going to jump right in and share our agenda. So what I'm going to cover today is, first and foremost, exactly what GDPR is, why it was created, what it does, what it covers. Then I'm going to move on to what you as marketers really need to know, highlighting a few specific areas. And then lastly, I'm going to talk about the actions that you need to take toward GDPR compliance. So with that, I'm going to go ahead and jump right in. Before I actually start sharing any information, I just want to kind of put this disclaimer out there. Crawford Group, we are marketers. We are not lawyers. So this information really is intended to be just that. It's informational. It's not legal advice. So we highly recommend that you contact your legal representative before you take any action to ensure GDPR compliance. All right, so let's go to what exactly is GDPR. So GDPR obviously is an acronym. It stands for General Data Protection Regulation. And to really understand GDPR, I think you need to start with the intention of the regulation, which is why it was created, right? GDPR was created to protect the privacy of individual people living in the European Union and European Economic Area. And it's intended to give them control of their personal data while imposing rules on how it's housed and used by companies. What it does is it specifically guarantees them a set of rights that businesses must honor when capturing and storing personal data for people living in the EU or the EEA. It covers any information that could identify a specific individual, things like their name, email address, location info, and even online identifiers like cookies. GDPR went into effect May 25th of this year, and it applies to everyone who does business with people living in the EU. I want to make sure that you really, really understand that this is not about the company, it's about the individual whose data is to be protected. So it doesn't matter how big your company is or where your company is located. What matters is where the individual person whose contact data you have, where they reside. And if they reside in the EU, then they are covered under GDPR. And the consequences of not complying with this regulation are, still a little bit to be seen in terms of how they're going to be implemented. We have already seen some lawsuits come out against Google and Facebook in particular, with upwards of maybe $8.6 billion in potential fines. This is something that, is just beginning. Litigation hasn't even started, so just because they're implementing this now as part of a lawsuit doesn't mean that they'll actually have to pay those fines. But the point is that the process of enforcing GDPR has already begun, and so you really want to take this seriously because the fines that can be implemented are upwards of 20 million or 4% of global revenue, whichever is bigger. So those are some really, really big numbers, and the intent and the level of the offense matters. So, I just want to reinforce that. So everything that you do around GDPR, you really want to make sure you're doing it with the proper intent and doing as much as you can to abide by and comply with this regulation. So what are those rights that GDPR actually is giving to its EU citizens and residents? They're very, very succinct. The first one is around giving them the right to get detailed information on what data your company has on them, where it's being stored, and how it's going to be used. In addition to that, companies have to take action on breaches that might compromise individuals' privacy, and they have to notify those individuals that that's happened within 3 days. The EU citizens and residents have the right to ask that your company transmit their data to another company. Say they want to switch to a competitor. That's actually enabled under this regulation in terms of that data sharing. It enables them to change or incorrect information stored about them or even revoke previous consent. So you have to be able to give them access to be able to do that. And lastly, it gives them the right to demand that you delete any and all information that you have on them in your systems. So these are the rights that the EU citizens are given under the GDPR regulation. And these are the things that we have to make sure that we're enabling as marketers and businesses. So let's talk a little bit about what marketers specifically need to know and about GDPR to make sure that we're helping observe the intent as well as enforce compliance. But before I do that, I want to share this quote from Robert Rose because I think it's really important that we as marketers look at GDPR as an opportunity. Robert actually says, you know, that GDPR is the biggest gift to content marketers in a decade. And that's because of this great quote here: data given rather than data gathered unwillingly is simply more valuable as a marketing asset. So, you know, think of GDPR as an opportunity, not just some kind of mandate and horrible regulation that we all have to comply with, and you know, some of the list shrinking aspects that people are concerned about. Those are definitely factors that are going to impact us. But when you think about the quality of what you're trying to do as a marketer, we're all trying to engage with our audiences. And when you have an active participant who is choosing to engage with you, you've achieved your goal as a marketer, right? So GDPR actually can help us get closer to the customer and really kind of, take advantage of that relationship in a much greater way. So the first kind of, section that I want you guys to really be thinking about is this concept of centralized data management and oversight, right? What that means is data must be securely managed, maintained, accessible, and in sync across all of your systems. So any changes that are made to someone's personal data needs to be consistent and integrated. So that means that individuals' data is, if it's in one place, it has to be that you have one place of record, but you have to have your other systems, your upstream, downstream systems, integrated in such a way that all that data stays in sync. If someone opts in or opts out, you have to be able to know that across your entire platform. So really make sure that you're prioritizing that data integrity and making sure that the integration with your systems is happening. They have to be able, again, as individuals, to easily access their data. So that means you need to make that data accessible to them to edit. That's something that, not a lot of us necessarily have done up to this point. But again, it's a really, really good best practice. So you want to make sure that you're really thinking about that experience for the individual as well as your systems and how they technically integrate. You need to appoint what's called a data protection officer, a DPO. This person serves as an overseer or a point of contact for GDPR. And this can be anyone in your organization. It does not have to be someone in legal. It could be a marketer. And, again, to Robert's point, and I think even in the blog that I pulled the quote from, he talks specifically how marketing has an opportunity here by taking this role of DPO to get even closer to the customer and help maintain their security or privacy of their data. Lastly, just to reinforce here, any security breach needs to be addressed in 3 business days and reported to that individual to let them know that that's happened and that their data may have been impacted. Explicit and proactive consent. This is the one that's so big for us, right? This is what's causing everyone to receive all these terms and conditions and privacy statements and email campaigns asking them to opt in. It's because of this need to have explicit and proactive consent. And what that really means is that we can no longer assume consent, right? We cannot just put some kind of disclaimer text on our messaging and that we're going to use their information. Instead, we actually have to give them the ability to manually themselves choose to opt in to these different types of communications. And so one of the things that we've done in the past as marketers is we've provided this checkbox to opt in. Going forward, in order to be GDPR compliant, that checkbox needs to be left blank. It cannot be pre-checked, right? It needs to, again, be proactive. The person needs to be consciously saying, yes, I want that type of information. I'm okay with you using my information in that way. One of the things that people recommend as a best practice is leveraging a double opt-in process. And what that is essentially when you get that opt-in and they check that checkbox, they're then followed up with an email. And that email, it actually is a general best practice from a kind of a data integrity perspective as well, because that email gives you the ability to validate that that individual's information they put in your form was valid, right? So it makes sure the email is correct and that they really do want that information. And so a double opt-in is something that's not required specifically by the regulation, but it is recommended. Lastly, and this is really important, I think especially for event marketing and just demand gen and things like that, third-party or shared lists still require explicit opt-in for your specific company to use. And so what that means is that if you're sharing any list, with a, whether you're on the receiving end of a list or you're actually the one who is giving it to someone else to share, you need to make sure that the explicit opt-in option for how that information is going to be used has been specified to that individual so that they can opt in for their information to be shared. You cannot assume that they are giving you permission just because they gave permission to an event, for example. You have to have that explicit opt-in for your company. The right to be forgotten. This is essentially where individuals can request from a company that all of their personal information be deleted and not just not used, but actually deleted from their storage systems so that it is no longer accessible. So it's all systems, from marketing automation to everything. One caveat, and again, I'm not a lawyer, so always make sure you talk to a lawyer, is it doesn't necessarily mean transactional data from, invoices, things like that, right? This is not meant to help people avoid making payments or to disrupt businesses, but it is meant to help protect that individual first and foremost. One of the things that you can do is you can anonymize your data. So what that means is that you can keep cookies that indicate to you what an anonymous individual has done, but keep it separate from who they are as a specific named individual. And if you keep that information separate, you can always put it back together again and have that opt-in. But in the short term, if you don't have the opt-in, you can keep it separate and still have some benefit in terms of reporting. And that keeping it separate but anonymous is also referred to as pseudo-anonymization, and it is what the regulation promotes in terms of the approach to use. Let's talk about event marketing. So event marketing specifically, again, you really want to make sure you have consent prior to any communications that you're doing, and that consent and the data you're capturing is integrated across all systems. Never assume that you have consent. Just because someone attended a prior event does not mean that they are giving you consent to communicate with them again about the future event. You have to have that specific opt-in documented where they give you consent to communicate about that. Update all of your registration forms. Make sure that you're getting that consent going forward if you didn't get it in the past, right? Because all data is applicable. Just because GDPR went into effect on the 25th of May this year and you got that data prior to that doesn't exempt that data. It is still applicable. Any individual living in the EU is applicable. So really make sure that you're doing your best to get that documented. You also want to think about how you're going to be interacting on the show floor, or, in your live events, and making sure that if there are any processes that you're training staff on how they need to be getting consent. During the event, really make sure that you've got your mobile apps and your badge scanners, that there's an opt-in included in that process within signing up for the app. And then also with the badge scanners, it's always, a double extra kind of recommendation to have the individual say, can I have your permission to scan your badge and send you information, right? So develop a script that people can use. I would also say that you want to make sure that if you're taking any information physically, so not digitally, but physically, like fish bowls where you're collecting business cards, you're doing a raffle, etc., make sure you have signage that indicates that by dropping your business card in this fish bowl, you are opting in to receive, marketing communications from your company. And, take a picture of your signage so that just in case you ever have any troubles, you've got that and you know that you've got that opt-in. And then people really think about using that double opt-in process after the event, especially with those ones that you captured manually, because people, they don't necessarily know what they're doing and they may forget what they're doing, but the important thing is that you've got it documented. And then lastly, remember to share your data within compliance. So again, if you're going to be sharing your lists or contact information, make sure that you either have an opt-in for yourself or that your vendors or sponsors, that they've also got an opt-in and that it's documented. So advertising and social. So there's a different, kind of aspects to advertising in particular. But again, everything around GDPR is really geared towards protecting that individual. So intent matters. If you're doing things that are not related to an individual by name, for example, you're usually going to be pretty safe. So contact-based retargeting, for example, if you want to make sure you're really doing what you need to do there, you want to use a double opt-in again, right? So this is where you know the individual's name. So if you're going to retarget to them, make sure that you've got that opt-in form, opt-in capability on your forms so that if they do fill out a form, you can do it again. Include ad retargeting in your opt-out process. So really make sure that you're being explicit, because GDPR covers not just the information, but how it's being used. So please make sure you use that opt-in for your cookie-based retargeting. Include a link to opt out on the retargeting ads themselves. And if they opt out, please, please, please make sure that you actually remove them from future retargeting activities. IP retargeting. So this is where you just have an idea of the individual's device via cookies, or at a corporate level, right? You want to target that domain of that company. When it's the individual device ID level, again, make sure you've got that permission via the cookie opt-in. If you're doing domain level targeting, in theory, it should be fine because you're just targeting a company, not an individual. But if you start to do any filtering where you're adding company job titles to that, and it gets a little bit, more targeted, just use caution because again, this is somewhat of a gray area for us still. Social media in general, in terms of how you're engaging with individuals on the platforms, are covered by the T's and C's for those platforms. But if you're going to do things like lookalike lists, uploading lookalike lists, make sure that you've indicated that that's a use within your opt-in preferences, right? So that people can say, I don't want you to use my information that way, or it's okay for you to use my information that way. And again, that's related to lists that you would be uploading that actually have individuals' names. Websites. So inbound and lead capture. Let's, again, really make sure that you've got that pop-up on your website that gets the opt-in, regardless of whether or not you're tracking personally identifiable information yet. Even if you're not, this is a good best practice. Go ahead and start doing this now. You want to have that, and people are, already getting accustomed to just clicking that and moving on. When you have your forms, take a look at all of the forms that you're using to capture personal data and make sure that your fields are consistent and that your opt-in messaging is super clear and tied to what needs to be communicated under GDPR. And again, while it's not required, consider using a double opt-in process just to make sure that people really are giving you that permission and you've got it clearly documented. Again, think of this as an opportunity from a marketing perspective. You've got people who are actively interested in communicating or receiving communications from you. Provide a robust preference center that really allows them to select exactly what they do and don't want. We as marketers, we can't get enough knowledge when it comes to knowing what our audience is looking for and what they want to consume. So think of this as an opportunity and make sure you've really broken things out so that people can be specific instead of just opting in or out, even worse, opting out of everything you do. Lastly, really, really, really stay hyper-focused on any affiliate websites or affiliate or partners websites, any lists that you're purchasing or anything that you're buying or using from other people. Make sure that you have explicit permission from the individuals to use that data. So, take a look at your contracts, take a look at your messaging, make sure that that opt-in is going to cover you. All right, so let's talk a little bit about what specifically you need to do to take action toward GDPR compliance. So, you do really want to take the time, if you haven't already, to do an audit of your data to really understand what you've got in terms of European or EU citizens in your database. And if you don't have opt-in permission to communicate and do what you need to do with those folks, run a campaign. You've seen a lot of people doing this. I'm sure you've received a lot of emails asking for your permission. Do this. Take the time, run the campaign, get that opt-in. That's the most important thing. Update your forms and websites to enable opt-in. Make sure that you've removed that checkbox and that you've got the right messaging. Make sure that you've got that forget me capability as an option in your preference center on landing pages where you're giving people the opportunity to opt in and out of specific uses as it relates to their data. And update your privacy policies. Make sure that they've got all the wording in there that they need to be compliant. And maintain and document any processes related to what you're doing around these types of activities. Lastly, make sure you have a data protection officer appointed and know who that person is and work with them to make sure that you're doing everything you need to be compliant with GDPR. Don't communicate with anyone in the EU if you don't have documented consent. I mean, this is just, don't do it. It's not worth it. We know that GDPR is going to be enforced. We know that there are fines and penalties, and we want to make sure that we are also respecting individuals and their preferences. And so if you don't have their consent, work to get it. And if they revoke their consent or they want to change their data, make sure that you've enabled that, and make sure that you also have enabled the ability for your systems to completely forget them. Don't use pre-checked boxes for opt-in, and don't use third-party or shared lists without explicit permission for your company. Lastly, do not assume anything. Talk to your legal representative, talk to your data protection officer, get a clear understanding of exactly what's required by your organization to ensure compliance. So here are some frequently asked questions I wanted to cover around GDPR to kind of just, help really sink this in. One of the things people ask a lot, is, I'm in America, I'm a small business, does this apply to me? Yes. Again, this applies to the personal data of the EU citizens, so the size or location of your company does not matter. The only thing that matters is where the individual whose data you have resides. Another common question is, what about Brexit? And the UK has said Brexit is irrelevant, so Brexit is not going to impact GDPR for the UK because they have said they are going to comply with it and it is not being affected. As I mentioned earlier, data collected before May 25th is applicable. So anything that's in your system today needs to have a record of an opt-in so that you are in compliance if they live in the EU. So make sure you do a campaign to get that opt-in if you don't already have it. Does this apply to individuals outside of Europe is another common question. And, frankly, the answer is no, it doesn't. But it is recommended that we just follow along as a best practice and implement this capability for all citizens of the world. There's a good chance that what is happening here under GDPR is something that may be adopted by other countries going forward. Best to get your ducks in a row. If you really aren't prepared to do that, at a minimum, you do need to do it for the EU countries, and you can do things like enabling people to select their country at the front end so that you can have a different system for them to opt in and out of and enable all of that functionality. But again, best practice-wise, best to start doing this for everybody. Is social media impacted by GDPR? So yes, it is impacted, and as I mentioned, Facebook is already getting a little bit of trouble under GDPR, and it'll be interesting to see what comes out of that. But in general, the basics of what you're doing as an organization on those social platforms is covered by their opt-in and their terms and conditions. Again, the exception is when you're thinking about using those platforms for retargeting and lookalike lists. You want to be cautious there and really kind of pay attention to what comes out in the future days. Are badge scanners and business card drop boxes included? Absolutely. Someone is proactively giving you physically their information. Many folks say this is a gray area, that the physical act of them handing the business card or dropping it in or giving you this badge to scan is enough, but I would like to recommend that you take that little extra step you're doing it and that you have clear signage around any physical capturing of information as well. So what about cold calling and emailing or direct mail, cold emailing? So, this is, again, an area that is still somewhat gray. Again, these are guidelines. They're not just some list of rules that we can, growth hack. Where we're going to see, not a loophole, but the reason this area is gray is because there's this concept of legitimate interest. And essentially, if you can say that you're reaching out to an individual based on what is perceived as a legitimate interest in your organization, then you should be okay to make that phone call or send them that direct mail. But make sure if you do that, you are giving them the opportunity to opt out of that direct mail or that phone call. And to be extra safe, log all of those activities in your CRM and make sure you're tracking all the opt-in and opt-out statuses for those kinds of activities. And again, talk to your legal department before you take any action just to make sure you're abiding by whatever internal rules your organization may be setting forth. All right, so here are a few additional resources for you. I've talked a lot about GDPR and broken it down for you, but there's tons of reading out there. I would highly recommend that you take a look at the official GDPR regulation itself if you really are passionate about this and want to know that level of detail. I provided that here. There's also a GDPR portal that has a whole bunch of information on all sorts of things. And then I've included a few links to some guides and a blog that can tell you a little bit more about GDPR, specifically as it relates to marketing. And I think it's really important, again, as marketers, that we think of this as not just something we have to abide by, but also something that can be ultimately an opportunity for us to get closer to our audience and have full engagement with them. So lastly, I would just like to thank you all for attending today, and I would like to remind you to please follow Crawford Group on LinkedIn, Facebook, and Twitter. Also take a look at our website. We've got, as I mentioned, a blog up there today about event marketers and GDPR. And we also have lots of job postings for marketers and other great information. And if you're looking for any support as it relates to your marketing workforce, whether you need one or a few or many marketing consultants, please do consider Crawford Group. We love helping people, and this is definitely something that I think y'all will enjoy. So thank you so much for your time today, and have a fabulous day.